So the DOJ, AG Bondi in 25 states and now multiple 2A organizations have joined to support the fight against statewide concealed carry ban laws. This challenge is now heading to the Supreme Court conference at the beginning of their next term. So let's break down what is happening. Now, before we jump into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. You guys know that 1st Phorm's an amazing company, but also one of the really cool things about them is they're pro-freedom, pro-America, and they support the Second Amendment and what we talk about here on the channel. So I want to ask you guys for a huge favor, go check out 1st Phorm, go support them because they support the Second Amendment. Not a lot of companies would sponsor these types of channels, so I highly recommend them, especially if you need pre-workout, protein powder, anything like that. If you're trying to get healthier, workout, check them out. And if you use my link down below and you order something $50 or more, they will give you a free 4-pack of energy drinks, which they're offering only to my viewers. So as I mentioned in the intro, in this video, I have some news for everyone in states like New York, California, Hawaii, New Jersey, and other states who are currently facing attempts to ban concealed carry within your state. The Hawaii Wohlford versus Lopez case is currently seeking emergency Supreme Court intervention. This challenge revolves around a preliminary injunction and the Ninth Circuit finding that states could put in place catch-all property bans, and to do so would be permissible even under the Second Amendment. Recently, to the surprise of many, the DOJ and AG Bondi have actually stepped up in support of this challenge, and they're pushing the Supreme Court to actually review this case. They filed an amicus brief to the Supreme Court arguing that it's finally time for the Supreme Court here to review these carry ban cases and review all the defiance that happened after Bruen. They also pushed for the Supreme Court to correct all the ongoing lower court defiance, again, which happened in response to Bruen, and they even mentioned rifle bans and magazine bans, that is something the Supreme Court also needs to review eventually. This effort has now been joined by 25 pro-2A states, so 25 states jumped on to also support this case, and also multiple 2A organizations have jumped on. So a lot of momentum has gathered behind this case, and it's now heading for Supreme Court conference at the beginning of the Supreme Court's next term in September. Now, if you're not aware, this case is a challenge to Hawaii's new laws on concealed carry that they passed in direct response to the Bruen ruling. This law, like others, tried to add more restrictions to concealed carry and create a default rule where individuals can carry firearms on private property only if the owner of that property provides express permission to actually do so. Hawaii again passed Act 52 in response to Bruen, and it overhauled the state's carry laws and really made them worse than the ones that existed prior, but already Hawaii had a pretty bad system. Keep in mind, Hawaii has already, had very restrictive concealed carry. They had only issued a handful of permits over 18 years, and then in one county, they had never even issued a single permit. Because of this, the plaintiffs, along with 2A organizations, sued the state of Hawaii to strike down this specific law. Now, on review, a district court actually agreed with the pro-2A side, striking down this law with a temporary restraining order, so a TRO, and then later they converted that to a preliminary injunction. In that decision, the district court actually blocked the private property rule as likely a violation of the Second Amendment, and they said that it was inconsistent with what the Supreme Court just said in Bruen. They argued that this structure in Hawaii was not consistent with the Second Amendment or with what the Supreme Court said in Bruen. Now, this case eventually made its way to the Ninth Circuit along with the California concealed carry ban, which I'm also a plaintiff on, and on review, the Ninth Circuit upheld the catch-all property ban and reversed the injunction issued by the district court. The Ninth Circuit relied on older restrictions on the hunting on private property to support this statewide concealed carry ban in Hawaii, and after that, the plaintiffs asked for the Ninth Circuit to review the decision en banc, but eventually that was denied. You did have judges like Van Dyke in the dissenting opinion of the court there, saying that the Ninth Circuit en banc panel should have granted review to this case, and by denying this review, once again, they were treating the Second Amendment like a second-class right. That has now led this case to seek emergency Supreme Court intervention, and that is going to conference during the Supreme Court's next term. Now, this case has a hard road to get Supreme Court review since, it's still at a preliminary injunction stage, and the Supreme Court has denied review of most of these type of concealed carry cases, especially when they're at this interlocutory preliminary injunction stage. However, with the United States DOJ now supporting this challenge, it has a better chance. The recent amicus brief filed by the U.S. government in the DOJ through AG Bondi, it stated that the near complete ban is flatly inconsistent with Bruen and the long history underlying it. Bruen recognized that an ordinary, law-abiding citizen has a general right to publicly carry arms for self-defense. One of the interesting things also in this brief is that you have the Trump administration pushing the Supreme Court to also take this case at an early stage and still review it, even though it's, dealing with a preliminary injunction. And the track record of the Supreme Court has been that they categorically deny review of these types of cases at this stage. But the Trump administration is telling the Supreme Court that they should take this case specifically because already at the lower court level, you had the state of Hawaii concede that nothing else needs to be developed at the district court level, that this is, at a legal issue kind of resolved already. And so now they're using that to say this has already been resolved. The state of Hawaii has conceded that it doesn't need a final merits determination, so it is ripe now for your review. Now, Hawaii responded as most anti-gun states do. In all of these cases, they argue that the case is still too early for review and that there is no circuit split on this issue, and the lower court should be given the opportunity to resolve this on the merits. They also tried to push back against the Trump administration stepping in and to support this case. They say that they're an uninvited guest. They say that the United States uninvited amicus brief does not change the calculus, so they tried to dismiss what the United States government just argued in support of this challenge. They also doubled down on saying that this case is too early for Supreme Court review and that the trial court should be given the opportunity to develop the record and rule on the merits of this case. However, Hawaii just contradicted themselves and kind of caught themselves in a trap based on what they argued in the Ninth Circuit. This was pointed out recently in Mr. Wolford's response brief. He stated that Hawaii argues that this court should deny this petition because the record is undeveloped. That argument is irreconcilable with the concession in the lower court that no such further development was necessary. At oral argument in the Ninth Circuit, Judge Schroeder asked counsel for Hawaii, "Can I ask you a question on the preliminary injunction point? What else is there left to decide and litigate in this case?" And counsel for Hawaii responded to the Ninth Circuit and the judge there that we think that there isn't anything. We think at the end of the day that these are not Second Amendment violations. So they say that there was a concession at the lower court in the Ninth Circuit that nothing else needed to be developed at the lower court level. There doesn't need to be more evidence or anything like that they are now arguing to the Supreme Court, and that they admitted that to the Ninth Circuit. And that was a judicial admission, and it's conclusive now on the Supreme Court and this current petition. Now, in this response, they also point out how Hawaii is trying to argue that their own state history, so state-specific history, supports this catch-all carry ban, and that's why it should be upheld. And they're essentially also arguing that their state history should override the nation's history. They state that Hawaii seriously errs in contending that because it has limited the carry of weapons in public spaces since at least 1852, its default rule is constitutional. Effectively, Hawaii is claiming that its tradition and its state tradition trumps the founding tradition. That assertion is self-evidently frivolous. So with the help of the Trump administration, the state of Hawaii might have actually got themselves caught in a little bit of a trap. A lot of their brief is focused on kicking the case for further development at the lower court level, but again, they already conceded at the Ninth Circuit level that that was not needed. This case is gaining a lot of momentum, and now it has been set for Supreme Court conference on September 29th, which is early in the Supreme Court's next term. So early Supreme Court's next term, they're going to consider whether they want to step in at an early basis on this issue of concealed carry bans at a state level in response to Bruen, and if they're going to also use, the Trump DOJ support for calling for this review, if they're going to use that to strike down this type of state defiance that happened after Bruen. So we're going to see how this plays out, but this is what's currently going on with the critical concealed carry ban case that is pending in front of the Supreme Court. As we get more information, I will let you guys know. If you want to support the channel, one of the best ways to do that is simply to subscribe to the channel. Also, if you want to support the channel, you can check out the free legal guide that we have. It's free to get. All you have to do is put in your email and we'll send you a PDF, and then you'll get some follow-up emails as well with some additional, free information. Obviously, I'm not your attorney. It's not legal advice, but just some educational material that you can, consume and, help you along your journey, especially, trying to remain to being a law-abiding citizen, especially when states like California, Hawaii, and others are trying to put in place these type of two-way traps. So as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.